The next matter to come before the court, excuse me, is Zachary Horseman versus Mercy Health-Lorain Hospital et al. I do note that we have more than one appellant in this case, but it's your understanding that you know that you have to divide your time however you see fit.
And if you want to know now, on behalf of Dr. Yin, in the beginning, we're going to take 8 minutes. Mercy will take 3. And then we're going to reserve 4 for rebuttal. But we can't really designate exactly right now. It depends on what they say.
Thank you for the information. As I had noted, both sides will have 15 minutes to present an oral argument. If not, we reserve it for 5 minutes. We've already taken care of how that time is going to be divided. In these oral arguments, please don't use the names of any victims or minors, as we are recording the oral arguments and they will be posted on the court's YouTube channel. I don't know if that's necessarily relevant in this case, but we always like to make that admonition. Also, please stay at this closer podium as it helps in our recording of the arguments. The judges have read the briefs for ready to see when you are.
May it please the court. My name is Doug Leek, and along with Dirk Schneider, we represent the defendant, appellant, Dr. Yin. And on behalf of Dr. Yin, we ask that this court reverse the jury verdict that was a result of multiple errors that denied Dr. Yin a fair trial. I want to focus on our first and third assignments of error with Dr. Cascone, the rebuttal witness, on behalf of the plaintiffs. Initially, and for both of those, these in and of themselves are reversible error. In assignment of error number 1, we raised the fact that the plaintiffs were allowed to do a switcheroo and swap their proximate cause expert, Dr. Edelman, from their case in chief and substitute him with their rebuttal witness, Dr. Cascone. The law is clear, according to the Ohio Supreme Court in Fung v. Waste Management, that a rebuttal witness is not to testify in a case in chief to support the burden of proof. A rebuttal witness is only to testify in response to the evidence and the testimony presented by the defense. In other words, to rebut, to respond. And in this case, there is no doubt throughout all of this litigation that Dr. Cascone was identified as a rebuttal witness, argued by the plaintiffs as a rebuttal witness, and ruled upon by the trial court a rebuttal witness. They produced their expert report timely of Dr. Edelman as the proximate cause expert for their case in chief and burden of proof. It was only after we identified our experts that they went and obtained an infectious disease specialist, Dr. Cascone, even though they knew all along this was a MRSA pneumonia case and could have had an infectious disease expert in their case in chief. The record is replete of why Dr. Cascone was a rebuttal witness and should have been limited to just that and not converted to a proximate cause burden of proof witness in their case in chief. First,
How long before trial did you get notice of Dr. Cascone as a witness?
as a witness,
Right.
well, we knew when they produced the expert report 9 months before trial,
9 months before trial.
but only as a rebuttal witness.
Was he deposed by
He
your?
was deposed
by
2
your-
months before trial.
Okay.
So chronologically, let's start with, he was identified in an email. Here is our rebuttal witness, Dr. Cascone. The PDF of the expert report was the rebuttal expert report of Dr. Cascone. We filed a motion to strike Dr. Cascone on procedural matters of being untimely identified. In response, the plaintiffs argued he was a rebuttal witness. He was rebutting our infectious disease expert. They argued rebuttal law, case law, the Fung case. And most importantly, in their brief in opposition to our motion to strike, they identified Dr. Zane, their standard care expert, and Dr. Edelman as their experts in their case in chief.
And how did that prejudice you? That it was switched from a case in chief, a rebuttal to a case in chief
Okay.
witness?
It prejudiced us Well, let's start first about their arguments on why we are not prejudiced. I'd like to take it that way. First of all, the plaintiffs argued that we were on notice of his opinions. First of all, we were on notice throughout the entire litigation that Dr. Edelman was their proximate cause burden of proof expert. We were on notice that Dr. Cascone was the rebuttal witness. In fact, when we took the deposition of Dr. Cascone, which is filed with the court at the very beginning, trial counsel started off by stating this deposition is taken because you're identified as a rebuttal witness and for the purpose of a rebuttal witness deposition. So then, they then argued that that was notice, that we knew his opinions. And that his opinions were essentially the same as Dr. Edelman, so we weren't prejudiced. Far from that, we were. Dr. Edelman was a different specialty. He was a pulmonologist. Dr. Cascone, infectious disease expert, only to respond to Dr. Sitterberg, our infectious disease expert. And then their testimony was not the same. And that's where we were mostly prejudiced. For instance, Dr. Edelman could not testify as to what was seen on a chest x-ray, whereas Dr. Cascone said he could. Also, with regard to the treatment, Dr. Edelman never talked about the administration of vancomycin, which became a very big part of their case through Dr. Cascone. And the reason we were prejudiced was effectively now, since they had different opinions, they were able to inject into their case in chief new opinions. Opinions that Dr. Edelman never had in their case in chief, had Dr. Edelman been the one to testify. Now they get Dr. Cascone that was only to be rebuttal to take those opinions and put it into their case in chief that never existed. That is trial by ambush. And where were we prejudiced? Throughout this entire litigation, we prepared for Dr. Edelman as a proximate cause expert in their case in chief. We prepared for Dr. Cascone as their rebuttal witness, as a rebuttal witness. It changed the landscape.
After the experts were designated, the court ruled, okay, yes, this doctor can be a rebuttal expert. Sometime prior to trial, was there some exchange of witnesses? And was this doctor still listed as a rebuttal witness, or was he just listed as a witness at that point in time?
Dr. Cascone was always represented as a rebuttal witness, never anything other. In fact, when the trial court made its ruling on the first day of trial, at transcript page number 557, the trial court explicitly stated, I allowed that expert report as a rebuttal report to the defense experts. The trial court also said that Dr. Cascone was responding to the defense. And in fact, so when the court ruled, it recognized it was a rebuttal witness, but still allowed it, and more importantly, there was no cause shown for this switcheroo.
But did the content of Dr. Cascone's deposition include the things he testified to at trial?
Yes, but it was only for the purpose for rebuttal. And once again, it was different testimony. So we were prejudiced, but let's talk about, had the court properly ruled and kept Dr. Cascone as a rebuttal witness, they would not have been prejudiced. First of all, throughout the entire course of the litigation, they never moved for leave to make him their case in chief. They could have supplemented the report of Dr. Edelman. They could have identified an infectious disease specialist at the beginning. But more importantly, on the day of trial, had they been told that you cannot use Cascone in your case in chief, they had the option of bringing in Dr. Edelman. But more importantly, the plaintiffs had the right to a redo. Had they really wanted to, if Cascone was not allowed, they could have voluntarily dismissed this case and retooled it. We don't have that luxury as defense. We cannot do that. We were stuck with a witness that we were preparing for as a rebuttal witness.
Can we move on to the impeachment issue?
And I was
And
just,
and as you do, please answer the questions, of course. I want you to know you've utilized 8 minutes.
very quickly then, in terms of the impeachment, it was compounded. Our hands were tied. The law is clear. If an expert puts their medical practice, credentials, credibility into the courtroom, they open the door. Here's a case of a witness who stipulated and agreed with the state of Missouri of violations of running a pill mill. And the prejudice is clear. In a county like Lorain County hit by the opioid crisis, this jury was left with the impression that it was an untarnished background. And this was their only proximate cause expert. Had a jury in Lorain County heard that, they could very well have discarded that witness's testimony and returned a defense verdict. So the outcome would have been clearly different. We were highly prejudicial just on those two. But when you consider the other errors, the circumstances of the death, the stipulation, mentioning mercy, the cumulative effect denied Dr. Yin a fair trial and resulted in an unjust jury verdict that should be reversed. Thank you.
Thank you, counsel.
Hello, my name is Dan Leister. I'm here on behalf of the appellant Mercy. We heard a little bit about prejudice from Mr. Leek. It wasn't just a rebuttal turned causation expert. It was a rebuttal turned causation turned standard of care expert. There's a key part of Dr. Cascone's trial testimony, which is at the very top, when he confirms, I'm only proximate cause, I have no standard of care opinions. Yet, when Dr. Cascone testified at trial, he said that a reasonable physician, after Ms. Horseman is admitted into the hospital, would have received vancomycin. Now, MRSA is how Ms. Horseman died. MRSA does not respond to the frontline drugs. It's resistant to the frontline drugs. It needs a drug like vancomycin in order to be combated, which means Ms. Horseman would not have improved without the vancomycin. It was incumbent upon plaintiff to establish their burden of proof for their standard of care expert, who was Dr. Zane, to testify that given the circumstances of Ms. Horseman's admission, if it had occurred, she should have been administered vancomycin within an hour, within 5 hours, within 24 hours, whatever the standard of care required. That was not in the plaintiff's standard of care case. Instead, Dr. Cascone, a rebuttal turned causation, turned standard of care, filled that gap and said, I think a reasonable physician would have expanded her prescriptions to include vancomycin within 24 hours, despite the fact that Dr. Cascone was admittedly approximate cause only. And for those reasons, a new trial should be awarded because the verdict was against the sufficiency and the manifest weight of the evidence. Thank you.
Thank you, counsel. Appellant, you will have 4 minutes and 16 seconds for rebuttal when the time comes. I know that we took a lot of time saying it, but is there any way we could put that demonstrative aid on the opposite side of the podium? Only because I know that they're going to sit there without facial expressions, but if that matter, if the court can see it, it also doesn't necessarily block the view. Thank you so much. You may proceed.
Thank you, Your Honor. May it please the court, my name is Dennis Lansdowne, and along with Dustin Herman, I have the privilege of representing the children of Carol Horseman in this case on appeal, as we did at the trial. In 42 years of practice, I've never been accused of a switcheroo or bait and switch. I don't appreciate it, and I didn't pull one here. Dr. Cascone was always on our witness list as a case-in-chief witness, including months before the trial and before he was deposed. Now, as to the basic facts of this case, they are not what the defense has put forth in their briefs, and all the facts regarding the underlying case have to be construed in the light most favorable to the jury findings. The facts are as follows. A woman is discharged from the emergency room twice despite signs and symptoms of infection and despite a flashing alert in the medical records that this patient may be septic. After her discharge, she dies at home less than 24 hours later, and the coroner determines that she had this pneumonia for days. Then the defendant emergency room physician makes up a story about calling this woman to cover up his negligence. That story is exposed at trial to be completely false. And the defendant's proximate cause theory in this case partly relied upon that false phone call having happened. And you can see that clearly at pages 1099 to 1101 in Dr. Citronberg, their defense proximate cause infectious disease doctor. So the defense lost this case because they were wrong on the medicine and because they had a doctor who misled them, not because of the order of the witnesses. Dr. Casconi, as I said, was always on our witness list as a case-in-chief witness. Mr. Leak misspoke. The witness list, which is 3 months before trial, it's docket number 63, lists all of our witnesses that we're going to call. It includes Dr. Zane, Dr. Edelman, Dr. Casconi, and it says specifically in a separate paragraph, plaintiffs reserve the right to call any witnesses needed to rebut the testimony. So that was separate. It was clear that Dr. Casconi was a case-in-chief witness from that point. And even before, and this is the timeline, and this is why we did this, to put this in some perspective, this case was proceeding during COVID, so there were lots of dates that were extended and moved on behalf of the plaintiff, moved on behalf of the defendant, and the judge was in touch with all of this. The judge held multiple case management conferences, pre-trials, and knew what the parties' submissions were. So when he saw that what happened here, when they submitted their expert reports, they, for the first time in the case, stated that, oh, she never had MRSA during the emergency room. We thought that was going to be stipulated. We thought, with the coroner's report saying that she had this for days, we thought that was going to be stipulated. But now we were going to have to prove that. And so we thought we needed an infectious disease doctor to cover that part of it. Dr.
Can you move your argument? I'm not hearing, I would like to hear more about the impeachment issue and then the evidence that didn't come in, and that is the Narcan, the marijuana.
Right. Happy to move on to that, Your Honor. With respect to Dr. Casconi, the defense, the trial court, as gatekeeper, wanted to keep this case focused on the medical issues in the case. The defense wanted to put on a sideshow of things that he'd done 10 years prior to trial in the state of his active addiction. That was 10 years ago. The judge said, you know, we're not going to do that. We're not going to hear that. Just as he said, he exercised his discretion.
Do you think that's an act of dishonesty, though? If you're a doctor and you have these things going on, and your license is involved, is that just drug use?
Well, he did, first of all, he didn't plead or confess to any pill mill thing. That's not what the record is about. But he acknowledged that his license had been on probation, not suspended, but it was on probation, again, because of this drug addiction 10 years ago. And so the judge said, you know, the probative value of this is very low 10 years ago compared to the prejudicial effect that this would have, the jury talking about these things. And that's what the essence of discretion is, just as the court, and I do give the defendants points for chutzpah for raising this issue when their defendant doctor was on probation for at the time of trial, for a very recent issue with respect to running a phantom clinic where he never saw the patients but put his name on there. So the judge wanted to keep the case on the merits and not on these sideshows. So the judge exercised his discretion, and that's what judges do. Remember, Dr. Yin was not only defendant, he testified as an expert on his own behalf. He testified the case in chief. So the judge said, we're not going to do either one of these.
Would you say Dr. Casconi was your most important witness?
No, I'd say the most important witness was Dr. Yin fabricating this phone call. I'd say Dr. Zane was the most important on the standard of care. Dr. Casconi was the most important on the proximate cause, and he was a proximate cause expert, despite the claim here that he's drifted into standard of care. He was a proximate cause expert. What we had to prove was a breach. That was proved by Dr. Zane. Dr. Yin didn't order a chest X-ray. So then we have to prove under the Bruni versus Tatsumi, breach, and then proximate cause. Proximate cause is that this failure led in a natural and probable, reasonable chain of events to cause the injury. And that's what he proved. He said in any hospital, this is what would have happened. She would have ended up getting vancomycin, and that's what treats it, and she more probably survives. And the jury got the proximate cause instruction. Nobody objected to the proximate cause instruction. Nobody objected to Dr. Casconi's testimony about the proximate cause when he testified. So we met our burden of proof. As to your other question, Judge Lanziger, about the so-called suspicious circumstances, again, defendants wanted to focus away from the essential medical facts. The judge said, we're not going to allow.
Isn't drug use medical?
Well,
If you ingest drugs or you receive Narcan?
she did not inject drugs. There's no evidence that she ever injected drugs. There's no evidence that she ever abused prescription drugs.
So in the autopsy report, that wasn't in there?
No, the autopsy report said categorically, clearly, there were no opioids in her system, there was no heroin in her system, there was no marijuana in her system. This was all a smear campaign. And yes, the EMS used Narcan because that's the standard protocol. They see a woman who's passed out, they see that there are prescription drugs, they were prescribed for her, she had back injuries, and so they used Narcan. Nothing sinister about it, but they wanted to throw that into the mix. So there's really nothing to that, and the court said, we're just not going to let the jury hear that, be focused on that. There's no medical evidence to tie it to the death. There's no medical evidence to tie it to the damages. They never proffered anything about how this could relate to the damages. And they were able to go into her prescription history, all of her history. They went into in very detail how many times she'd been prescribed this, the surgeries that she'd had from this car accident. So all that was in there. And they made whatever arguments they want. They never made an argument that this somehow affected her relationship with her children or anything like that. So the verdict, the jury found both negligence and proximate cause based upon evidence that was appropriately before it. The verdict was well within the jury's power as given to them by the Constitution and the wrongful death statute. There was testimony about all the elements of damages for this mother of these two children, very close relationship, and so the verdict was well within that range, and there was nothing about the argument or anything else that unduly influenced the court or the jury, and no evidence that was done. So for all of these things, all of these errors, Your Honor, we did prove the standard of care, we proved the proximate cause, that all that evidence was in there. Mercy's argument about standard of care was never raised below. They weren't participating in the trial, so they never raised this issue below. And so we have a clear record here of the judge exercising his discretion, as he did throughout this trial, throughout these pretrial proceedings, both to the to the benefit, if you will, of the plaintiff and to the defendant. It was an even-handed approach to the trial, and we rest on our briefs, and we ask that this verdict be affirmed in total. Thank you, Your Honors.
Thank you, Counsel.
Your Honor, with regard to the impeachment issue, the plaintiffs hired Dr. Cascone. It was public record that he entered a settlement agreement with the Missouri Board of Health about his practice, fraudulent prescriptions, fraudulent documentation, all regarding his practice. Once he testified about his practice and his credibility, it became an issue and opened the door. And the jury was left that he, with the impression it was his background was untarnished and impeccable. And dealing with opioids, very important for a jury to hear it, it would have been rejected. The plaintiffs, upon appeal for the first time, tried to compare Dr. Yin and Dr. Cascone here. It's apples and oranges. First of all, there's no motion practice with Dr. Yin. There's no ruling with Dr. Yin. They want you to believe there is some quid pro quo here where you don't get into Cascone, we don't get into Yin. It just wasn't that situation. You have to isolate and look at Dr. Cascone. He was a hired expert with all this baggage that would have changed the outcome.
Is there a specific agreement with Dr. Cascone or some agreement on the record, some finding somewhere that you presented to the court that he agreed or was found to have committed fraud in prescription?
It's all part of the motion practice. Everything is before the court. And what's important also on this issue, all that is part of it. The stipulation was presented as evidence in the motion limiting practice, is that at page 558, when the trial court judge ruled on this, the only basis was we are going to give people a second chance. We're not talking about his personal issues about addiction and rehab. That could have been tailored out. What we're talking about is the way that this expert, who comes in to be critical of an expert or a defendant and proximate cause, brings his practice in. That's the cross-examination, the fraud, the dishonesty, the probation. And importantly here too, is that we couldn't get into the fact that he became board certified in infectious disease, the case he is testifying about, during this probation period. We should have been able to explore that. What were you doing during probation? Studying to become an infectious disease board certified expert. So for that reason, that's reversible error. But also, we were able to do this when we had the benefit. In red, we identified on their thing. I know it's small, but you can just see the red. Throughout there is rebuttal witness, rebuttal witness, rebuttal witness. They never affirmatively identified Dr. Cascone as a case in chief. But what they did do was they identified Edelman and Zane, case in chief. And what they excluded here was the trial court statements at page 557, saying, I allowed this witness as a rebuttal witness to respond to the defense witness.
Well, they're saying on 12-8, if I remember their exhibit, that they filed their plain witness list and they listed all these doctors as witnesses and no one in the rebuttal witness. Do you object at that point and say, hey, wait a minute, Dr. Castone's in the rebuttal witness?
There was no label put next to the witnesses' names. There was no case in chief.
Okay.
The first time it ever happened that he became case in chief was on the first day of trial. And what's important in our motion limiting, we were moving to exclude him procedurally as a rebuttal witness, but also in our motion limiting, we said at a minimum, he shouldn't testify in the case in chief. It was not until the first day of trial in chambers when they said, we are not using Dr. Edelman, we're now using Dr. Cascone, and that became the issue, saying, wait a minute, you can't do that. According to Fund versus Waste Management, rebuttal witnesses are rebuttal witnesses to respond to the defendants, but by allowing him to be a proximate cause, burden-proof expert in their case in chief, allow them to get different opinions from Dr. Edelman that they now got rid of. And that is clear, trial by ambush, to allow that switch. And it is called a switcheroo because that's what happened. It happened on the first day of court in chambers. They're using Cascone. And the trial court committed error there and abuses discretion on the impeachment issue. And we ask that the jury verdict be reversed.
Thank you.
Thank you.
And thank you both, all of you, for your presentations today. The court will take the matter under advisement. We will issue a written decision which we mail to all parties to this appeal on the day that it is released by the clerk of courts, as well as posted on the House Supreme Court website. Thank you, enjoy this beautiful